So welcome everyone in person and those joining us online to today's presentation on Insolvency 101 from Scott Boucher and Candace Formosa. So Scott Boucher is a partner at Norton Fulbright who practices general commercial litigation with an emphasis on insolvency and restructuring and estates litigation. He assists clients and other lawyers on a wide variety of matters, including contract and property disputes, insolvency files, including receivership, CCAA, bankruptcy and foreclosure proceedings, wills variation claims, and trust litigation. He has appeared before the Supreme Court of British Columbia, the British Columbia Court of Appeal, and the Supreme Court of Canada. Candace Formosa is an associate at Norton Rose who practices in all areas of commercial and civil litigation. She assists clients and senior lawyers on a wide variety of matters, including contractual disputes, tort claims, property-related disputes, and, of course, insolvency files. Candace has appeared before the Provincial Court of British Columbia and the Supreme Court of British Columbia. So Scott and Candace have a prepared presentation today, so I will let them get started with that. After their presentation, I'll be asking some prepared questions about insolvency practice, and then we can close things out with audience questions. So without further ado, please take it away.
Thank you very much, Kevin. Nice to meet everyone in the room and online. I'd like to talk today about insolvency, sort of 101. And it's not going to be sort of a step-by-step of summary of insolvency law on a substantive basis. There's going to be elements of that. But I do want to weave in to this presentation, practical considerations, things that might not be apparent from the black letter law of insolvency law. And so I'm happy to be interrupted if you want to interrupt me with a question at all. There's going to be a time at the end, but we are used to being interrupted on our feet when we speak. So I'm happy to answer any questions if they come into your head as well. And thank you for the very nice introduction. I'll sort of introduce ourselves, I guess, a bit more on the personal level. I am from Vancouver. I went to UBC in undergrad. I didn't go to UBC for law school. I went to Dalhousie out east, partly because this building was being constructed when I was applying for law schools, and I did not want to sit in Buchanan for another 3 years of my life. And I see it hasn't really been changed as I walked by it today. So I went, and I came back, but I was always going to come back, and I got into where insolvency law and the other areas I practice, not because I was enthralled with insolvency law as a young boy. I wasn't enthralled with insolvency law when I was sitting in your position. I didn't take any insolvency law courses. I fell into it in practice, and one of my pitches today on insolvency law is that it is way more interesting than it might sound. And it's actually a great practice area, especially for young lawyers. So that's going to be my pitch. That's a little bit about me. I'll turn it over to Candace, who has a much more interesting background.
Not him. So hi, I'm Candace, and I did my undergrad at UBC as well, and then for law school, I went to Thompson Rivers. I've been an associate with Norton Rose now since, I want to say I got called in 2021. And like Scott, like when I was in school, I wouldn't really say that insolvency law is something you hear about or consider that you want to practice. For my first summer after law school, I ended up working for a firm that exclusively did insolvency law. And as a junior, as Scott said, it can be really fun and interesting because if you like the litigation side, you end up in court a lot on small matters. And so you get to practice and maybe get over the fear of appearing before a judge at a very young call. And then going to Norton Rose, starting in my second summer when I articled there and all the way to now, insolvency law there is a lot of intricacies to it. You get a lot of kind of legal problems, and in school, if you like that idea of having a little bit of a complicated scenario and fast-paced environment, it definitely can be a fun practice.
Okay, so without further ado, Insolvency 101. So this is meant to be a general overview of insolvency law with some practical considerations. We're not going to go into specific details of case law. And at the outset, just as maybe a show of hands, how many people have taken insolvency law courses already at law school? 1, 2? Excellent. So we can largely make up the rest. Does anyone intend to take any bankruptcy insolvency law courses in law school? Okay, well, wait till the end of this presentation before you make up your mind. I think having a grasp on insolvency law is very important for all lawyers, with some exceptions. It affects about almost every legal practice that I can think of. And it's not just, okay, a company has gone bankruptcy or someone's gone bankrupt or there's a restructuring proceeding and then all of a sudden that's when the insolvency issues arrive. They often arise before any of that happens. They arise when, as a solicitor, you're trying to put together the framework of a deal or a transaction. If you don't have an appreciation of insolvency principles as to what might happen if the counterparty or your own client ends up in an insolvent situation and what the process would look like in that scenario, it's very difficult to give that upfront advice to your client on how a deal could be structured. Or if you're approaching litigation and you don't know what might happen if the other party becomes insolvent in the course of that litigation, it completely affects your strategic approach to the litigation itself. So it's not just an area of law that applies if you are a dedicated insolvency practitioner. It really touches on any area of law that you can think of in practice. So that's one of my messages today in terms of why insolvency law is very important. This is a very simple point, but this is one of the points that come across most when I talk to anyone about insolvency law, and that's lay people or experienced lawyers in different areas, is the difference between insolvency and bankruptcy. Insolvency is a financial state of affairs. It's not a legal state of affairs. Because you're insolvent, on a financial perspective, doesn't mean you are bankrupt, and that means bankruptcy is a legal status. So lots of companies and entities and people are insolvent right now. That doesn't mean they have to do anything about it. Doesn't mean anything is going to happen to them. This is sort of one of the largest things, one of the most prominent things I come up with is people come to me and say, I think we're insolvent. Do we have to file for bankruptcy? Or do anything? And the answer is no, you don't. There might be some advantages to doing so, but just because you're insolvent doesn't mean anything else happens. And that terminology is important. And generally, there's different tests for when someone is insolvent, but I would say the most common one is when you're unable to pay your obligations as they generally come due. And there's different variations on that, but that is what we talk about when we're talking about insolvency generally. And then I'll ask Candace to summarize.
So as you can see on the slides, there are two main statutes that deal with insolvency law. So the first is the Bankruptcy and Insolvency Act. That can deal with personal bankruptcies. So if one of us individually went bankrupt, that would be the one that you come under. It can also deal with companies that go bankrupt, and when you're looking into the future, it's whether there's even like a viable chance that the company will continue. If there's not, then they'll likely just be put into bankruptcy and the company won't make it out the other end for the most part. And you could also do proposals under the Act, and that's a scenario in which you might make a proposal to your creditors where you pay them less than the amount due, and see if you can come to a deal, and then when you come out the other end, and all that debt is forgiven. The Companies Creditors Arrangement Act is the act that I actually prefer, because it's a little bit more fun in my opinion and view, on the law level, and it's made for larger companies that have significant assets and different ideas, and they will go into a proceeding, and the idea is for the company to be restructured and come out the other end. So a lot of the times you're finding different creative solutions on who can buy this company potentially, or what assets can be sold, or different ideas for the company to have a going concern on the other side of the proceeding. So the process for advancing creditor claims varies between the different acts, but there is a general consistent theme, is that all creditor actions are stayed once the legislation is engaged, which means that if you had any type of claim against a specific creditor, against a specific debtor, you can't advance it. It must go through the process of the proceeding. We won't bog down into the details because I don't think it's exciting for this purposes. And when you're under this process, there's a difference between a secured claim and an unsecured claim. Does anyone know the difference between the two? No. We got one. So an unsecured claim is essentially someone owes you money, but you're not secured against any assets of the person. And so you're just under a general pool with all of the other creditors, and whatever is remaining in the estate at the end of the day will get distributed to you equally. If you have a secured claim, it likely means that you have some type of asset that your debt was advanced for. And so as a secured creditor, you would get, say you were secured against a house or some type of property, you would get the proceeds out of that because that was part of your secured claim. There are a bunch of other statutes on the slide here that can be relevant in insolvency proceedings. The only one that I'll really focus on is the Personal Property Securities Act, known as the PPSA. What's interesting about that act is there will actually be revised, and there'll be a new act coming, I think it's in force in 2025. So if you do end up learning about secured claims or anything like that during school, that act will be substantially revised to make it more efficient. But what the purpose of that act is just, it outlines all the different enforcement mechanisms that a creditor can take, essentially, in a very broad summary, to action on a claim that they have against someone. So whether that be selling a property or garnishing wages or different aspects, it's all the different enforcement mechanisms. And it also takes care of how you register a security interest if you do have something against property. Again, I won't bog down to the details because I think this is only Insolvency 101.
Okay. And so another something we keep to be aware of is sort of how the insolvency regimes are engaged. So a lot of people think of your creditors forcing you into a bankruptcy, forcing you into some sort of insolvency proceeding, and that certainly is one of the ways. But the other way is a voluntary process, which is the debtor assigns itself into some sort of bankruptcy protection. And we'll touch on this in a second, but the main purpose for that is seeking the court's protection. And this slide says under the CCAA as an example, but that applies to bankruptcy under the BIA, a bankruptcy proposal under the BIA, the CCAA, or any receivership. There's a stay of proceedings. And this is one of the main hallmarks of an insolvency proceeding, is what it does is it establishes an orderly process for all of the creditor claims of a specific debtor to be dealt with in an organized manner that's not chaotic. Because what would happen otherwise if a company or a person was in an insolvent state financially, generally means their creditors are calling. They have maybe a line of credit that's come due, they have a mortgage, whatever it is. They have debts and the creditors are coming. And the creditors are going to be coming, and if they have security, if they have a secured claim, they're going to be enforcing the security against that whatever assets they have security over. If they have an unsecured claim, they're going to start doing things like garnishing bank accounts, garnishing wages if you're an individual. They're going to be taking steps that are going to really disrupt your life. And if you are an ongoing business, going to be disrupting your business operations. So that is not good for anyone. The creditors, the debtor, our judicial system, nothing. So what the stay of proceedings does is it comes down out of nowhere. That's another hallmark of insolvency proceedings, is that they come down like lightning from the sky. There's not much notice, and people don't like that, but that's just how it is. But the reason is, if you give all your creditors notice that in 21 days I'm going to be seeking court protection and getting a stay of proceedings, well, then the next 21 days before that happens is going to be pretty chaotic because all of your creditors are going to come calling. So the stay of proceeding happens like in the middle of the night kind of thing, and then it prevents all of that from happening. No, as soon as that proceeding is initiated, as soon as that first order is made, your creditors are generally prevented from taking any further steps. And it allows a centralized process to deal with all of the debts, all of the claims through one medium, which is the insolvency proceeding. So it can happen voluntarily, and it can happen involuntarily. So this is the classic one. You petition someone else into bankruptcy, you bring an application for a receiver to be appointed over their assets and undertakings. That's sort of happening against you, typically brought by secured creditors, generally to protect their secured claim. But it can happen initiated by the debtor, or it can happen initiated by the creditors. And I'll let Candace explain bankruptcy.
So I gave kind of a brief overview when we were talking about the different statutes before, but as you can see on the slide, there's many different steps to what a bankruptcy proceeding encompasses. Essentially, when someone is petitioned into bankruptcy, the bankrupt ceases to have any legal capacity to deal with their property, including disposing of any assets. So the trustee now has control of all of the property of the bankrupt, whether that be a company or an individual. And the trustee is essentially what you would view as maybe a referee who decides which creditors get what, preserves certain assets of the bankrupt, and can recommend to the court whether a bankrupt should be discharged. And so you can get scenarios, like scenarios that we've dealt with, is it might be an individual that's gone bankrupt and they have spent all of their money on maybe gambling or fraudulent activity, and then they come to the court, they're petitioned into bankruptcy, and they want to be discharged, and they have no assets. And so the trustee and the court, the trustee will make a recommendation, and the court will ultimately decide what type of discharge an individual might be deserving of, and maybe that they have to work for a certain amount of time and pay off a certain amount of money before they can actually be discharged. So there's many factors that kind of come into not only the assets and property that are relevant at the time of bankruptcy, but you're looking ahead and whether any additional assets should be added to the estate. There's different considerations on a company side. It's not necessarily the same on the individuals. A creditor must prove a claim. So if you believed that you were owed money from the individual or the company that's in bankruptcy, you must submit a proof of claim form. And ultimately, the trustee will decide whether to approve or disapprove of the claim that you have provided. You can prove your claim without a judgment, which is kind of a fun aspect. So for example, if you had pending litigation against a certain company, and that company in the middle of litigation goes into bankrupt or becomes bankrupt, you can essentially then get your judgment against this now bankrupt individual without having to prove and actually go through the end of the litigation process, which is one fun thing about insolvency, because you could skip potentially years and years and years of litigation and just get your money paid out. The problem on the opposite side is that you're essentially proving your claim against someone that maybe has zero assets, and so that's so great that you get maybe a penny worth of what your debt is. The only other thing that maybe we'll briefly touch on is that in certain pre-bankruptcy debts might not be discharged, and so there's different rules within the Bankruptcy Insolvency Act about what actually survives bankruptcy. So fraud will survive bankruptcy. The government sometimes will make sure that their claims survive bankruptcy, of course. And so it's not always just a clearinghouse for debts, which is how some individuals look for it. You won't actually necessarily clear your debts, even if you go bankruptcy, depending on what they are. Yeah, we'll just go to the next slide.
Sorry, one point on that as well. Sorry. I just wanted just so we have, because we have this slide up here. These elements here, as we'll go through, most of these are common across every insolvency proceeding. So this is not unique to bankruptcy. The one that's unique to bankruptcy is probably the first one, in that it's the bankrupt's assets actually vest in the trustee. So it's not, that also happens in a receivership, but as we'll get to a little bit later, the difference between restructuring proceedings and liquidation proceedings is often, one of the differences is when in a restructuring proceeding, which is not a bankruptcy, but which is more a bankruptcy proposal or a proceeding under the CCAA, the Companies Creditors Arrangement Act. In those proceedings, the debtor is still in control of its business. So there's a different court officer that's there to supervise, but it's not a trustee. The trustee steps into the shoes of the bankrupt. So the bankrupt no longer has control over its operations, can't make decisions for itself. The trustee makes all decisions, steps in, has all powers. That's quite a different thing in the bankruptcy versus a restructuring proceeding. I just want to highlight that. But everything else here is generally what happens. You have an automatic stay of proceedings that sort of stops the chaos. There's a process for gathering up and liquidating, if it's going to be a liquidation proceeding, the debtor's assets, supervised by or either run or supervised by a court officer like a trustee. Every creditor submits a claim in the proceeding and can't advance claims elsewhere. The claims are then determined with the assistance of the court officer, and the proceeds from the liquidation are paid out in priority based on the scheme under the Bankruptcy Insolvency Act. So that actually, and then there's some discharge. At the end of the day, the bankrupt insolvent entity is coming out discharged either to no longer operate or to operate in a restructured manner. This is kind of the core elements of any insolvency proceeding. So we're going to talk about different ones, but I don't want to give the impression that this is unique to bankruptcy. This is kind of the framework for all of them, and there's just subtle differences in what the purpose is. And on the last point that Candace raised about fraud and things that aren't released by bankruptcy, just as a personal note, not that you all look like you won't commit fraud or assault people. If you do commit fraud or assault people, those debts are staying with you forever. So there's no bankruptcy that's going to wipe that out. The legislature has, as Candace said, specifically identified things that do not fall under the rehabilitative purpose of insolvency law, because it is rehabilitative. It's supposed to be focused on a honest but unfortunate debtor, is the language, to help them get through their financial distress and move on with their lives. That doesn't apply if the debts that you're trying to get out from under are because you defrauded someone or assaulted someone. There's a couple other ones. So for the litigators or future litigators in the room, an interesting point here is if you're looking at someone, a defendant, who may have solvency issues, and think about that when you're crafting your pleading. Because if you can allege and prove that the debt arose as a result of one of those enumerated factors in the BIA that aren't released in a bankruptcy, and you think that as soon as you sue this person, they're just going to go into bankruptcy and try to wash their debt away, that might inform how you craft your pleadings if it's available to you. Because if you can do it and get that debt associated with a fraud, for example, then that person is never going to be out from under your thumb as a creditor, with some exceptions. But restructuring. So this is the one of the two kinds of insolvency proceedings. Bankruptcy is more of a liquidation. Restructuring is just that, more of a restructuring. And so the idea in a restructuring insolvency proceeding, which is one that's done under the CCAA or one done under the bankruptcy proposal proceedings, typically, is at the end of the proceeding, the business is going to come out, or under a consumer proposal, the person is going to come out with a way forward that'll allow them to keep going while their existing debts have been compromised. So, you know, in a personal bankruptcy, obviously the person continues to exist after the bankruptcy. But in a company bankruptcy, that's not the case. Like at a company bankruptcy, at the end of it, you're just liquidated, it's done. The company's no longer. The assets are done. The restructuring is more of the idea, and this is what you see with insolvencies like MEC in 2020, Target, all those ones. The idea is that we are going to get rid of the elements of our business that are not profitable, that are causing us the concerns, based on a compromise that we work with our creditors on, and we're going to keep going in a streamlined model of ourselves. That's what restructuring is, and that is the main difference between restructuring and more the liquidating proceedings, which is what a typical bankruptcy would be. So if you can meet the $5 million threshold of having assets or liabilities, the CCAA I don't know why it's called the CCAA as opposed to the CCAA. Whenever someone says CCAA, it like makes me nuts. I don't know why. It's generally, yeah, it's generally the CCAA. And it is a statute that gives the court and parties the most freedom and flexibility to craft a practical solution to an insolvency situation. So the court has extremely wide discretion under the CCAA. Too much in the perspective of most, general litigants and counsel who do practice in general commercial litigation. Because, for example, the court in the CCAA can force you to force another counterparty to a contract that you have, even though it says there's no assignment of that contract. CCAA court can come in and say, nope, that's going to be, this is your new counterparty to the contract, and I don't care if it's a term of 10 years remaining, and you didn't have any choice in this. This is who you're now dealing with. There's a great number of discretion and flexibility in terms of the remedies that a court can provide. And one key element here, as with in a bankruptcy proposal proceeding, is that the debtor remains in control of assets and operations. CCAA proceedings on a practical level can be quite fun. They can also be not fun, but they can also be quite fun because they typically involve like a room full of counsel. Because when you get into that $5 million threshold and above, you'll get pretty complicated businesses that have a lot of creditors, probably, a lot of stakeholders. And so stakeholders is a term that's used a lot in insolvency law. It's meant to mean more than just creditors, because in a bankruptcy or in any sort of insolvency situation, there are people who have a significant interest in the proceeding that aren't necessarily creditors, employees who may not have who may not have like wage claims, but their careers may be in jeopardy depending on what happens in the insolvency proceeding. Shareholders are less important because equity claims, your claim as a shareholder always comes after everyone else in terms of the creditor list. But there's a broad number of people who are often affected by a CCAA. We were counsel for Mountain Equipment Co-op when it was Mountain Equipment Co-op before they went through their CCAA proceeding in 2020. It was something like 20 stores, thousands of employees, a business that's been around since the 70s. In that case, it was a cooperative, so there was members. A lot of people involved. But why I say it's fun is that it's not like most litigation, it's you and the other counsel in a room before a judge. Maybe you get 3 parties or 4 parties, maybe. In insolvency, there's often like 20 parties in the room, and there is. They often have to fly lawyers out from Toronto because there's not enough insolvency practitioners in Vancouver to handle all of the different parties that could be involved. I've had that specifically on one matter. They had to have the biggest courtroom in the courthouse, and they still didn't have room for all the counsel and parties. And that can sound chaotic, but what it means is, and this is a point I'll make later when it gets to like the real practical points of insolvency law and my pitch to why all of you should become insolvency practitioners, is if the insolvency bar in the city you work is good, if it has good people, if it's fun people, reasonable people you get along with, what it means is that like every CCAA or every insolvency proceeding becomes like you and your friends in this industry teaming up against some of your other friends in the industry on a particular file. On the next file, you'll be teaming up with the people you were against on one file against the people you were with on the other file. And you kind of, it's not like teamwork, but like it's like having a first year class all practice the same area and all kind of team up or be against each other at different times during the year. It can be quite fun. You can get to know people, and it kind of increases the reasonableness of everyone in the room if you know that the way you act towards other counsel on this file may impact how you're able to work with that other counsel on the next CCAA when your interests are aligned, or you share a common purpose with their clients. But anyways, CCAA proceedings are very fun, they're very big, and they can be quite complicated. And here, I won't go over all of the ins and outs of a CCAA proceeding, but this is generally the format. It's commenced by petition. There is next to no notice that's going to be given for that petition. Typically, you might, if you're the debtor and you have a senior secured creditor, like you have a main bank, like RBC or institutional lender, that has, your primary, credit line and bank accounts with, you probably give them a heads up before to make sure that they'll be okay with it, or at least see what the temperature is. But it comes at the middle of the night type thing. And you get the initial order, which grants all these things. In the CCAA, it's not a trustee, it's a monitor. And that turn of phrase reflects the court's officer's role in the CCAA, which is a restructuring proceeding for the most part. Sometimes you can have liquidating CCAA, but the monitor is not in the shoes of the debtor. They are monitoring. The debtor is still in control, making decisions, engaging in their operations in the normal course. So slight difference there, but this is generally some elements of CCAA proceedings. The other option for restructuring is one of the other options is under the BIA itself. So the Bankruptcy Insolvency Act has this sort of the standard traditional bankruptcy liquidation proceeding, trustee appointed, in control, in the shoes. We're going to liquidate it. We're going to see what the proceeds are. We're going to distribute it based on the creditor's claims, and then the company is done. There's a whole part to the Bankruptcy Insolvency Act that is focused on bankruptcy proposals, and that is largely similar to a CCAA proceeding, and it kind of follows the same kind of process. It's available under the BIA for those people or those entities that don't meet that $5 million threshold that's required on the CCAA. So if you're not a large business like that, but you still want to restructure, you can do so under the BIA proposal proceedings. And essentially, with some exceptions, the same regime will apply, and you'll have a chance to restructure. And these are some, nitty-gritty in terms of days of filing and things, but the same kind of idea. There's a stay of all proceedings, and it commences with a notice of intention to make a proposal. And in terms of the next steps of proposals, this is a bit detailed, but generally what happens in a proposal is it'll be started by a notice of intention, which will come out of nowhere, right? And that's where the stay of proceedings gets set. And then within 30 days, what the debtor will do is provide a proposal to its creditors. And the proposal, the basic idea of a proposal is that I'm insolvent. Here's what's going to happen if I assign myself or am assigned into bankruptcy. Here's what will happen under a liquidation of my assets. Here's what the secured creditors, if I have them, will take. Here's what's going to be left for the unsecured creditors. It's going to be, usually it's zero, say, for example. The alternative under restructuring is, I acknowledge I have these claims and these debts against me. Instead of forcing a liquidation and the sale of all of my assets and the stop of my operations, let me propose a compromise that'll allow me to continue on after the proposal with a compromise that should give you a better result, speaking to the creditors, than what you would achieve under a traditional bankruptcy. And that's the pitch to the creditors. It's, here's the proposal of here's how we're going to give a distribution, typically, to our creditors, and it allows the creditors to vote on it based on their class in the priority scheme. So the proposal trustee, because again, they use a different term, I don't know why they just don't use a monitor for this, but it's not. In CCAA, the court officer is a monitor. Under a bankruptcy proposal, it's a trustee, a proposal trustee. They will review the proposal and issue a report, a brief report, when it's put towards the court for approval, and when it's been given to the creditors, confirming that the outcome of this proposal is likely to generate a better result than a traditional bankruptcy. And that's generally the main issue. So these proposals, You can get extensions. That 30-day period is not ironclad, and the extensions are usually granted. And so eventually a proposal is presented to the creditors. They get to vote on it. If they vote it down, there's an immediate bankruptcy. It's deemed to be a bankruptcy. There's no time in between. So that's always a risk if you're going to issue a proposal, is that if it doesn't, you kind of want to get a sense of what your creditors are going to vote before you make it. But if the creditors accept it and vote in favor of it, then you go on to get it approved by the court. And assuming there's no issues there, the proposal will be approved, implemented, and as soon as it's implemented, all those debts are compromised and discharged, and you can proceed on as a new entity or a restructured entity. And then, of course, if they vote it down, it just goes into a traditional bankruptcy, and you're just liquidated.
Receiverships are fun as well. You've heard us, I think, talk about a lot of different avenues for insolvency and where they can lead to. I'll try and make this a little bit high level just because we've given you a lot of information today, but receiverships are a fun option to use. And so it's a state in which a receiver is appointed over the assets of a debtor company. And it can be kind of fun if you're the receiver, because you essentially get to take control of a business for a little bit and decide which assets to sell off for a creditor in order to satisfy their debt. And then you kind of leave and let them go on. And so maybe you take over, a winery for a little bit, or some type of golf course or a different company, and kick, sell some assets, do a few things, and then get out on the other end. When the receiver is in control of the debtor's business operations, they have to act in a commercially reasonable manner. So you can't just, go sell off the largest asset that they have and then crash the whole business. That's not the goal of it. They have to still operate within it. Sometimes receiverships, so we have a matter in which we represented the debtor companies, and as the receivership went on, the receiver requested that the debtor companies be petitioned into bankruptcy because it was clear that there were no assets that would allow them to continue operating, even if once they took control. So you can have receiverships be the first step. Receiverships can be appointed both under the Bankruptcy Insolvency Act, which you've heard a lot about today, but there can also be an equitable receiver. And so it's not necessarily driven by the two main acts that we've discussed today. The model order in a receivership proceeding, it provides the receiver with a bunch of different powers. So as I mentioned, it's taking possession of the property, managing and operating the business, selling assets. But the big thing that Scott talked about earlier, which is the same in receiverships, is that there's a stay of proceedings. And so you still have that protection from different creditors going against you. I think I'll end it there, because I know when I first learned about insolvency law, all of these different avenues started to blend together, and we've given you quite a bit of information today.
Yeah, and just before we leave receiverships, I've always thought that the insolvency law, you work, as lawyers, you work a lot with accountants. So when we talk about a trustee or a monitor or a proposal trustee, who they are really just accountants. So that's, for larger matters, it's PwC, E&Y, FTI Consulting, KPMG, like those are who the trustees, monitors, and receivers are. So we work a lot with them as counsel. It's very interesting because if I was an accountant, and I'm very much not, acting as a receiver seems like a pretty cool way to be an accountant, because you're basically thrust into being an entrepreneur in random businesses all over the place. So like, the clients I work with who act as receivers or trustees or things like that, like they'll all of a sudden, like a proceeding will happen and they'll fly out to the Okanagan and start taking inventory in a wine cellar, start making decisions on how to market wine stocks, how to adjust pricing, have to learn how the business operates very quickly, manage the business for an indefinite period of time, and then perhaps make decisions about how to sell parts or a whole of that business. So like, I don't know, as an accountant, I think that would be a pretty cool part of the job. The receiverships are interesting for a number of reasons, but from the accounting perspective, I think that would be kind of one of the cooler jobs to have. In terms of priorities, priorities can be a little bit messy, but there is an enumerated set of priorities under the BIA. So you can always look back to that to see how things work, but often it ranks, well, there can be obviously arguments about how a claim should be considered in terms of priority. There's a great CLE series of course materials on priorities. It's just called, I think it's called straight up priorities. And as just a practical advice generally, if you are going to practice in litigation or otherwise, CLE online is maybe my go-to source for guidance, commentary, and things like that. You know, Hallsberry's and all the other ones with LexisNexis, they're all great too, but the CLE online, that resource, well, they have like practice advisor guides, which set out a lot of information in a very practical manner, but you can also just search course materials for decades. So, you know, there are people in Vancouver with Vancouver, you know, BC legislation, Vancouver issues, court process in mind, and there's usually an answer to most questions you have if you just go to CLE online. So I always push that to everyone. It's to my mind the best. Anyways, CLE has a great thing on priorities and well is a great resource for understanding priorities. And so there's some super priority claims, and so these can be frustrating, especially if you're a secured creditor. As a secured creditor, what you've gone out and done is you've negotiated security for the debt that's owed to you. And what that should mean is that you have control over what's going to happen to that asset if things go sideways, if you're in first place as a secured creditor. Super priority claims come out of nowhere and interfere with your priority, or can. So they're typically from the CRA. CRA, you know, through the legislature grants itself a lot of very powerful tools to make sure that it gets paid, which kind of makes sense, I mean, for everyone. Doesn't make sense to the secured creditor who's getting, you know, primed by the CRA. But, you know, typically they arise where there is, with the exception of unpaid wages, they arise where basically the company or the entity or the person has received funds that are not theirs. So they come up, they're called deemed trust claims often. And so typically they arise in the situation of GST, PST, I'm glad we don't have to talk about HST anymore, and income tax withholdings for employees. So basically the company, I'm assuming it's a company in this situation, has received money from either customers in the terms of GST and PST payments, or have withheld funds from their employees on the basis of income tax. Those funds were never the company's funds, right? Like, it was always, they were just handling those funds for the federal government, essentially, CRA. So that is what allows the CRA to have a super priority claim, which doesn't, they don't have to give notice of it. They don't have to, there's no registry of a deemed priority claim. They get to go back and say, okay, fair enough, you got this mortgage, you know, registered on January 1st, 2023. I see that, you've registered it completely, you've perfected your security. Unfortunately, before that time, the borrower failed to remit 4 years worth of GST and PST to the federal government, and also failed to completely remit all of its income tax deductions that it took from its employees. So those charges come in priority to your mortgage, even though there's nothing wrong with your mortgage. Because if that arose before the mortgage was registered, it's a super priority. It jumps you in the queue. So that can be very frustrating for secured creditors. One of the few things that can do that. The other thing that can, the term is prime a secured creditor, is administrative charges in an insolvency proceeding. So this is also one of the reasons why secured creditors often try to oppose and resist a CCAA, a bankruptcy proposal, or anything like that, because the costs of these proceedings are usually very high. So, and this is being recorded on YouTube, so I'm not going to comment on some of the fees of non-lawyers, but it's complicated work, like it really is, and it can be extremely complicated work, especially when you're running a business, when you're supervising the operation of, say, an operation like Target or MEC or any of the very large businesses that have to be restructured. It takes a lot of time and a lot of resources. And so the admin charges that are imposed in the course of an insolvency proceeding for both the trustee, the monitor, receiver, whoever the court officer is, their own charges, the charges of their counsel, because they're entitled to be represented by counsel, and often the debtor's counsel as well, are secured by charges, like priority charges usually, against the assets of the debtor. So essentially, these charges are imposed by the court in priority to other secured claims. And that will drive secured creditors nuts, as you can imagine. Because you've negotiated the first place security and all of a sudden you're second place behind hundreds of thousands of dollars of professional fees, for example. And so that's another type of super priority kind of. One very quick thing on super priority claims, this is kind of nitty gritty, but I always found it interesting. You can flip some of these super priority claims from the CRA by simply petitioning someone into bankruptcy. So there's some of these priority claims can be effectively taken from super priority to unsecured debt or like enhanced security, enhanced priority, but behind secured creditors by simply the fact that a bankruptcy proceeding has been started. It seems unfair. I always feel like sheepish when I go to court and explain that that is why we're doing that, but it's completely accepted as a reason to do it. It's completely allowed. The only one affected is the CRA, and so that always keep that in the back of your head if you're going to practice in this area. It's one of the reasons why people actually assign themselves into bankruptcy sometimes. Okay, so general conclusion. There's a number of options in the insolvency regime. It's not just about bankruptcy. And there is a lot of cooperative and creative things you can do in insolvency proceedings. And they are geared to be a very practical mechanism to solve financial issues. So you'll get, it is really a blend of legal and financial decision making. And you actually see that reflected a little bit in who practices insolvency law. So myself personally, I don't have much of a financial background. I came into law as like I'm going to be a commercial litigator doing any type of litigation. But there are other insolvency practitioners, and I only do litigation. I don't do any solicitor side work. There are other firms and groups, insolvency groups around the country that have a different model where the insolvency practitioners are not really litigators outside of insolvency law at all. The other side of their coin is lending on the solicitor side. So you have that dynamic of I'll act putting lending deals together, and then when they go south, I'll act as insolvency counsel in sort of insolvency litigation. That's quite a common model. But weaving through all of these issues is a combination of financial pragmatism and legal principles. So there's often really creative solutions involved. There's something called reverse vesting order, RVO, which Candace can speak about if you have questions about. That's sort of the latest and greatest in terms of creative ways to restructure businesses, not without controversy. But it can also be quite costly. And that is something that's always in the court's mind and in the parties' minds is, do the costs of this insolvency proceeding justify the potential benefits that can be obtained through proceeding with the insolvency proceeding as opposed to letting things just die on the vine or wind up or let the creditors just come for what they can take and walk away. So it's a number of competing principles, but it's a very interesting area of law. And before we finish, I'll just sort of speak a little bit about sort of the practical stuff, because when you're in law school, it's so interesting, but it's all theoretical with some exceptions like moots and things like that. It's not until you actually get into the practice of law that you really get a sense of what goes into practicing a certain area. So when I was in law school, I loved criminal law. I took a bunch of criminal law courses. I never really thought I would go into criminal law, but I turned to the areas I practice now, which are insolvency law and trust and estate litigation. Didn't think for one second I'd do either of those in law school. But what I learned through articling is that the practice in these areas was very much what I wanted to do. So it was a lot of exposure to court early on. I probably did 60 to 80 court applications in my articling and first year as an associate. And that was probably 10 times more than anyone else in my peer group. There's just a lot of opportunity to get into court because in a lot of situations in an insolvency matter, because there's so many parties, there's so many people interested in the outcome, that you're not always the first chair on an issue. Sometimes you're just there to observe or to make small submissions or to adopt submissions or to sort of just kind of ease yourself into litigation. So it's a great opportunity to get into court all the time as a junior associate. And it's also really interesting to see how insolvency works. And then I'm not going to talk about this in the estate and trust side because this is not about what we're talking about today, but similar thing, lots of opportunities to get into court. And that's what really drew me to it. The other thing is that the bar in the insolvency world in Vancouver is fantastic. People are very reasonable. People like each other. People get along. We do great business development and conference activities. We have a young insolvency practitioners conference every year and a half to 2 years, which is always held in Las Vegas for 4 days. There's very light on the substantive conference on that trip, and just more about getting to know people, deepening relationships. It's a very reasonable and nice group of people to work with, even if you're against them. So that's something that doesn't come across when you're in law school, and you have to kind of figure it out when you get into the law. But it's something to keep in mind because there's a big difference between spending the next 40 years of your life with people who drive you nuts every day and versus people that you actually are friends with when you're not working opposite them on a file. So that's my general pitch for insolvency law as a practice. And
I don't know if you want to ask questions or else I can go on a spiel. But I think
you can keep going. I have some questions to ask, but it's we've still got plenty of time, and
sure.
So feel free.
Yeah. So I think like the best part of insolvency law, and Scott has talked about a lot. For background, I don't know if I really explained exactly. I think Scott did the way that our firm works, but I am a commercial litigator, and I have, especially in insolvency law, because it interests me. But if you do like the insolvency side or the litigation side, but sometimes files are quite slow, like it will take years to get a trial date. You'll be bogged down in disclosure of documents, reviewing documents, coming up with the best arguments. With insolvency, as Scott has mentioned many times, it comes down immediately. And so I can picture a time where I typically work with Kieran or Scott on insolvency matters at our firm, and I can remember Kieran giving me something and we had to file the next morning, which sounds stressful, but it's actually a really fun experience because it causes you just to think about what the issue is, put it down on paper, and then get it there. And then you show up the next day in court and you all get a chat about it with a million different other parties that are there. And it gets you away from this idea of worrying about everything needs to be perfect, which I think happens a lot of the time, what you're used to, versus it cares about the outcome. You're actually thinking about the practical realities of what you're doing, what matters, what information does the court need to hear. and how can we do this in a practical method to get out the other end. The other pitch I'll give for insolvency law, which Scott is jealous of, but you never know. It may take you to different parts of this world. I'm on a file right now that started as a receivership, that's turned into a bankruptcy, that's led me to going to Vegas, next week Australia, and later probably a different country. And so I think, although that's a unique circumstance that Scott may be a little bit jealous of, I think there's a lot of opportunities to put you in different areas and try different things. As Scott mentioned, there can be the transactional side, and so commonly you will see in many firms that you do both. There was a firm that I was at that you're called almost like a solicitor because you do have a little bit of the transactional side and the litigation side. So if that's something that you're interested in, there is a good chance to get involved in that within the insolvency bar in Vancouver. You can just look out to which firms maybe offer that model opposed to our model. That would be my pitch on insolvency law.
No, a good point about how files can happen out of nowhere, but like, you know, it's, if you're in litigation, this won't apply to sort of solicitor practice, but there's some, like, I find like file fatigue is a real thing. Like the way, you know, our court system is not, you know, it's got issues. Like it can take 5 or more years to get closure on anything, and you know, after 4 years of the same counsel and the same issues and the same, you know, just going over, like, you can get a bit exhausted. Not going to be a problem in insolvency law because the files come, they get determined, they get figured out fairly quickly, relatively incredibly quickly, and then you're on to the next thing. And you know, sometimes they do drag on, but you kind of keep it fresh a little bit, and you don't have the fatigue. Also, if you don't like document discovery, you don't like document disclosure process, you don't like reviewing thousands and thousands and thousands of documents in every piece of litigation, then insolvency is for you because there is 0 document disclosure. It is all affidavits, get into court, get it quick results, and move. So, you know, that is one thing that I was like, as a junior litigator, I was like, doing both commercial litigation and also insolvency litigation, and I kept on being like, wow, like I'm not doing any document disclosure in insolvency, and it's very nice. So if you find yourself not liking document disclosure, it's another reason to get into insolvency litigation. But happy to turn it over to any questions you have.
Yeah, so thank you very much. I did have some questions prepared, but you hit on a couple of them in your presentation. And so just in the interest of time, I thought maybe I'd give other members of the audience an opportunity to ask questions. I think there might have been a question online, although I'm not sure. But certainly any questions in the audience. I think I'll let the students go first.
Hi, thank you for the presentation. So I have 2 questions. The first one is about the creditor voting proposal one. I imagine the creditors, they would all have like severe conflicts of interest against each other's. Like some creditors that are high in priority, they probably would have gotten everything, whereas creditors that are lower in priority might not have gotten much. In that case, why would they vote for such a proposal?
Okay, so it really comes down to a cost-benefit analysis, and you're right. So in terms of the different priority, it's a good point. Often they'll be voting by class. So the unsecured creditors will vote as a class, secured creditors will vote as a class. Because yeah, you're right, they may have different interests. But the ultimate question for each creditor, and will decide and will affect how they vote, is whether or not this proposal, if I believe that it will be implemented, and you know, if I trust that it is what it'll say it'll be, will this be better for me than a bankruptcy? Because at that point, there's only going to be 2 options. It's either going to be the proposal, because once the proposal started, there's 2 outcomes, right? It's going to be voted on, approved, and implemented. At which point, you know, you voted for it or you voted against it, but it's still going to be implemented against your will. Or 2, the voting fails, and then you're right into bankruptcy. So the creditor can figure out what, in that circumstance, what it wants to do, because it's not like there's a third option where I somehow get a better recovery some other route. That's not, at this point, it's going to be either what's going to happen in a bankruptcy, which in most cases with a proposal, it's like you're going to get 0 or like a cent on the dollar, versus a proposal, which in most cases, the creditors are voting in favor begrudgingly, because the proposal might only reflect 5 cents on the dollar of recovery. But as long as it's more than, reasonably more than a bankruptcy scenario, that's all that they need to do. So yeah, I get a lot of creditors holding their nose but voting in favor, and just because it's not worth it for them to see what happens in a bankruptcy scenario.
Thank you. And my second question is kind of a blend of bankruptcy, insolvency, and maybe corporate law even. Is also kind of like a bad faith practice one. It's like, let's say a company has like multiple business units, and some are doing better and some are not doing so well. But the ones that are doing poorly, they could bankrupt the entire company. So is there a way for the company to just like kind of group those business units together into like a new subsidiary, or the ones that are doing well into a separate subsidiary, so that basically just shield itself off in a way that's kind of like bad faith, because they're really trying to screw over their creditors and protect themselves. But is there a way to prevent companies from doing that, or is that kind of allowed?
Totally, it's a great question. So this is one of sort of the one of the funner areas of insolvency law, is that this specific issue, because and Candace has dealt with this in one iteration of this very recently, and it does. You're right. It does mix into corporate law. So, as I think everyone here will know, generally, the courts will respect the theory of corporate personality, and just because I am a parent company and my subsidiary owes a debt, that's not my debt, at least subject to particular circumstances, essentially fraud, where the court will step in and pierce the corporate veil to attach the debt to beyond that one entity. So piercing the corporate veil in itself is a mechanism for that. If you can establish that the other side has used the corporate structure in a way that's meant to defraud others, you can make the argument that the debt of one entity should be attached to another. That doesn't necessarily involve insolvency law, that's just a general corporate litigation tactic. In insolvency law, there's also concepts like substantive consolidation, which is not firmly rooted in Canadian jurisprudence, it's more so in the States. But what it essentially does is we have all of these entities, most if not all of them will be insolvent entities on the financial test, right, insolvent. Even though my debt is just with, say, corporate entity A, because the corporate entities in the group didn't separate their assets, financial records, internal workings, it's resulted in I'm not able to properly determine what assets my entity has versus the other entities in the group, essentially, or it's frustrating, or it's not cost effective to separate each debtor entity with their creditors because it's not clear. You can substantively consolidate all of the debtor entities into one proceeding and treat them kind of as if all the creditors are just creditors of all the debtors. It's more complicated than that, but that is one way to do that. But one of the more common ones is, I think one of the first things you mentioned was bad faith, right? So especially in terms, well, in all insolvency proceedings, but in particular proceedings under the CCAA or restructuring proceedings, you have to demonstrate on an ongoing basis your good faith in what you're trying to do. So if there was any suggestion that there was something, transactions happening that indicated bad faith, that would be a tool for a creditor to apply to terminate the proceedings. So there's a couple different ways to address that. It's very common. And there's also just the standard commercial remedies of fraudulent conveyance, fraudulent preference, and have their own acts. They're really weird acts. I don't know if you've ever seen the Fraudulent Conveyance Act or the Fraudulent Preference Act. They're like ancient acts. The Fraudulent Conveyance Act, I think, is 3 paragraphs long. There's like nothing to it. but it's very important to know how it operates because, for example, if in that scenario you had one entity basically funneling assets, this is a common thing, funneling because they're aware of maybe impending creditor claims or an existing creditor claim that's going to start to turn ugly. They start getting rid of assets to related entities such that when it comes time for that creditor to enforce, oops, all your assets are gone. So it's a dry judgment and no harm, no foul because you have all these other related entities to scoop up all the benefit. So that's a fraudulent conveyance or a fraudulent preference, and typically, so you can go ahead and unwind those based on those acts without engaging anything in the insolvency regime as well. Or you can bring those claims in an insolvency proceeding if one has been started. But there's lots of remedies for that. It's a very common issue. Thank you. Yeah. Great question. Actually, the more interesting work in insolvency law is when you're working for a debtor. That is it's the biggest job typically you'll have as legal counsel because you're not only just thinking of dealing with creditor claims at the outset. Before the insolvency proceeding starts, for example, you have to give strategic advice as to what we're going to do here and how it's going to play out. And so it's a much more involved role when you act for debtors, especially when you're talking about larger debtors in a restructuring scenario or things like that. So from the debtor's perspective, a lot of this is focused on not necessarily disputing creditor claims because you're insolvent, right? So you're not coming out of this at the end of the day with money in your pocket for the most part. Your creditors are going to be taking, if it's a liquidation scenario, for example, your creditors are going to be taking the assets of whatever entity is insolvent. And so the focus is not so much on, disagreeing with every single cent and dollar the creditors are claiming against you. Sometimes you do take issue with a creditor claim if it's been inflated or isn't appropriate. But it's often more on things like limiting the liability, making sure the liability isn't being extended to other groups in the corporate group or other entities in the corporate group, or making sure that directors aren't being faced with personal liability, because that's something that happens in the insolvency space as well. Is there's some debts that are not just imposed on the company, but can be imposed on the directors personally. So it's often about limiting, focusing the proceeding as clean and simple as possible, minimizing pain, minimizing public exposure, maximizing the value of the asset, especially if, for example, there is a guarantee. So say as an individual, I've guaranteed the debt of a company that I'm in charge of. I'm very motivated to make sure that the assets that are being liquidated under the debtor entity are being maximized so that my exposure on the personal side is limited. So it's a lot of that kind of issue, and often it's a lot of fighting creditors who want to disrupt the insolvency proceeding, especially if that's a debtor initiated proceeding, because I think it's helpful. It gives me some more space, it gives me some more time. Who knows what's going to happen? Interest rates drop. All of a sudden, there's a better market for this asset. I can get out from insolvency, or it gives me more options. Debtors are always trying to buy time. Creditors are always trying to limit that time. And creditors are always and trying to stymie, not always, usually trying to stymie the debtor from getting creative, buying time, working on proposals, things like that, because every day that passes, the claim of the creditor is increasing because of interest, because of just opportunity costs, not having that money. And all of these proceedings, as I mentioned, imposes costs from the top down, priming the creditors. So the debtor's job is largely, once they've initiated the proceeding, is make sure it stays on track, make sure creditors aren't derailing it, and then minimizing the exposure if there is exposure to personal people, and then just kind of getting through it and making sure that the recovery for your assets is maximized. But it's actually a bigger job than acting for creditors.
How
So it's tough to say. Inherently, it's going to be mostly creditors because in any proceeding, there's only going to be one debtor, and there's going to be between 1 and 100 creditors. So there's more creditor work that comes up. So I would say mostly creditor, but especially on the advisory, because another part of this, we're insolvency litigators, but a good portion of our work is not in actually engaging in litigation, but it's just advising business lawyers about their clients who are either in the insolvency zone themselves or are dealing with a counterparty who might be. So in that sense, I work for debtors a lot, but just not in the insolvency proceeding stuff. For the insolvency proceeding stuff, it's just more limited because there's only one and there's a bunch of creditors. So, but it's nice to have a mix because I think most people do have a mix because it helps you appreciate the other side of the coin when you're advancing your claims. I don't really know of anyone who's like just acts for debtors or just acts for creditors. The big distinction in insolvency, though, is individuals and corporate insolvency. We've dealt with individual insolvencies before as creditors because you're kind of forced to. Like if you have a client who's owed a debt by someone, they're going to ask you to help figure it out. But we don't act for personal bankrupts, really. It's an entirely different regime under the same act that has similar principles but different practical considerations. Like if an individual is bankrupt, like there's not much to do, and often it's just the trustee is going to run that with them in the most case. So I don't like to touch that stuff really, and not because it's distasteful, because I don't have enough experience in it and it's different. So. Yes. So, without being a solicitor myself, I do have something to say about this because because I'm not a solicitor, I have to turn to other people when someone needs a deal to be made in the context of an insolvency proceeding. So the deal making and negotiations will happen more often in a restructuring insolvency than a liquidation insolvency, but it comes up and it can be very important. For example, in that NEC matter, the CCAA's purpose was to approve essentially a sale of the business as a going concern. All of the solicitor's work that's required to sell a business like MEC or Target or Sears, all of that work that would otherwise happen outside of insolvency has to get done in the insolvency proceeding, right? So you still need all of those deal makers to work on that file, but there's a bit of a different tinge to it, and that is you have the court process and you have the court's authority to approve the deal. And so I spoke about this very issue with a colleague of mine in Toronto, who was more the opposite of me on the other side of the coin. He was the deal-making insolvency guy, and we actually worked together on that MEC file. But his thing, I think this is common among solicitors, is like the vesting order cures all. And what that means is in an insolvency order, if you have a deal you have to consummate as part of that insolvency, it's going to be approved by the court. That's almost always a requisite. And it's especially if you're selling assets, like real property or whatever, you're going to get a vesting order from the court. And as opposed to a normal transaction where, issues of, charges or encumbrances or claims that might thwart a deal, that's up to the parties to figure out through due diligence for the most part. And there's some risk there. In insolvency, the vesting order comes in and just eliminates. Like, this deal is going to go ahead, all claims and encumbrances are vested off, any interest, no claims, it's done. So I think the deal making in insolvency can actually be quite interesting and fun for solicitor side because it's a little bit different than normal deal making, and you have some benefits in terms of the court process that allows you to get around obstacles and things that might not otherwise be available to you. So that's just one example, but it's, the deal making insolvencies, it's fast paced. Another, cool thing, I do understand when we say fun and cool, like I understand that it might not come across that way where you're sitting right now. I mean, Australia. I mean, well, like for me, I can't go to Australia right now. It's midsummer. I'll die. You know, these deals are quite interesting, and I think, for example, there's like bidding process, this happens in foreclosure proceeding, which is a form of insolvency, but it also happens in receiverships or anything where there's a deal. Say there's a deal that's being made for an asset of an insolvent entity, and we're going to sell the asset. The notice of that sale is kind of cast out, and someone can generally come into court at the hearing and say, I have a better offer than that. And then you get into like a sealed bid process, like in real time in the courtroom, where you have to like get sealed envelopes and you pass it up to the court and the court reviews them. Like there's a lot of like really interesting deal making processes that happen in insolvency law. So I would encourage you to look into it. It's an interesting area for solicitors as well.